I'm going to begin the presentation with a bit of a history lesson, taking us back in a time machine to tell a little bit of a story and give some context on how we reach this particular point in dealing with expert witnesses. And then I will also conclude the remarks with identifying the new rules and providing some additional background on the presentation uh, of the rule by the committee and its various approval processes. And Donna Williams will conclude the panel, also a former colleague of mine for many years at Baker McKenzie, and she will speak to and summarize the many cases that have already popped up since the new Rule 702 was issued uh, uh, in December of 2023. What is Rule 702? Well, essentially, it establishes the criteria to determine the qualifications of expert witnesses in federal courts. And remember, this is a rule that is limited to federal jurisdiction only. Some states follow the federal rules, as you know. Other states carve their own paths when it comes to admissibility of expert testimony. The initial federal Rule 702 was issued when the entire federal rules of evidence were codified and issued in 1975. And essentially what we'll be talking about today is how this new rule supplements and clarifies what remains the leading Supreme Court, U.S. Supreme Court decision on admissibility of expert testimony, the famous Daubert versus Merrill Dow Pharmaceuticals decision. And we'll talk a little bit about that. But now it's kind of going back to history, because I think it's important to know the journey that has led us to this point. Legal historians using the English Commonwealth system have found evidence of expert testimony and the criteria for admissibility going back to the 1780s in England. And there are a scattering of cases, primarily in England, and then some cases in the US in the 19th century where experts were used. But however, it really wasn't until the early 20th century when we began to see the whole question of who is an expert. How do you determine if an expert should be allowed to testify, if they are sufficiently qualified, made its way into the federal courts. Probably the first examples of experts being used in the United States were in criminal trials. Medical experts to speak to wounds and possible causation for a source of death or an injury. And then as mental capacity became an issue, psychological testimony was recognized. It's one of the leading cases from the early 1920s is the decision in Coca-Cola versus Cherry-Cola, which allowed expert testimony from psychologists as to whether Cherry-Cola's trademark would cause confusion for consumers by being too similar to Coke's trademark. And in that case, the DC Circuit recognized that expert testimony of that psychological nature would be appropriate and admissible. But that leads us to pre-Daubert, what was, I'll call it the OG of expert witness jurisprudence, and that is the decision of the United States Supreme Court in Frye. And the Frye case is put before you. You can see the citation. What was Frye all about? Well, Frye was a criminal case on which the defense attempted to introduce polygraph testing as a recognized form of evidence to determine whether or not a defendant actually committed the crime. And Frye also wanted to introduce expert testimony to explain the test and the rationale and why it was a reliable predictor of veracity. Well, this was an interesting case in that Frye impacted both criminal and civil law by, addressing this issue, and ultimately the court rejected the attempts to use polygraphs, and there still, as people who do criminal cases know, that's kind of was the end of polygraph testimony in many criminal cases. And the Frye standard was that scientific expert testimony was admissible only if the expert's scientific knowledge was derived from methods that were generally accepted in the scientific community. And in that case, the trial court, and affirmed by the Supreme Court, concluded that the use of polygraph evidence was not generally accepted. Now, the Frye standard proved to be, it really limited novel leading edge techniques, even though it had kind of a circuitous and not that robust of a precedential or case history after it was decided in 1923. Between 1948 and 1975, when the federal rules of evidence were issued, Frye was only cited 48 times, and some state courts followed it, some didn't. It really was a bit of a hodgepodge. And what's also interesting is that when the original Federal Rule of Evidence 702 was published, it didn't even mention the Frye decision, nor did the committee notes. And the Federal Rules of Evidence and their amendments are done, by an expert committee consisting of judges, law professors, practicing attorneys. They are ultimately also vetted and approved by the United States Supreme Court and then enacted by Congress as the final step. So nothing about Frye in that original history of FRE 702. Well, that leads us to the case that most modern practitioners are most familiar with, and that is the Daubert case. What was Daubert about? Well, it's not an employment case, nor was Frye. There, the two plaintiffs were minor children, and their parents. They sued Merrill Dow Pharmaceuticals, claiming that Merrill Dow's drug, Benedictine, had caused the two minor children to be born with serious birth defects. Now, Merrill Dow presented robust expert testimony showing that there was, in their view, conclusive evidence that there was no causal linkage between the use of Benedictine and birth defects. Plaintiffs offered up probably 8 different experts, really at the cutting edge of statistical and scientific knowledge, showing that yes, those studies relied on by Merrill Dow were allegedly flawed, and that there were alternative explanations to the negative studies. However, the trial court determined that the plaintiffs' experts' opinions were not generally accepted under the standard of the old FRE 702 and under the Frye test. And the case really provided a perfect opportunity for the Supreme Court to clarify rules for addressing the expert standard. Should expert evidence and testimony be generally accepted, or should it meet some other set of requirements? And in essence, the Daubert court created 4 guidelines for considering expert witness testimony. And the 4 are whether the expert's theory or technique can be and has been tested, whether the theory or technique has an acceptable known or potential rate of error, the existence and maintenance of standards controlling the technique's operation, and whether the theory or technique had attained general acceptance. The key takeaway from Daubert I guess if we try to distill the four factors into one, is that scientific expert testimony need only be based on reliable principles and methods to be admissible, provided all other evidentiary rules are satisfied. Well, Daubert continued to spawn litigation because it wasn't completely comprehensive, and two subsequent U.S. Supreme Court cases attempted to provide some clarity on the issue. In Cumho Tire versus Carmichael, the Supreme Court said that the Daubert standard for experts would apply not just to scientific experts, but to all witnesses offered up as expert witnesses. And the General Electric case was important because it essentially said that the expert's methodology, as opposed to the expert's conclusion, was really a critical factor. And it also established an abuse of discretion standard for determining whether or not the trial court committed error in admitting or failing to admit an expert witness's testimony. Now, despite the three cases from the Supreme Court, GE, Daubert, and Cumho, there was still confusion across the federal circuits. And there was a real split across the circuits, with the Eighth Circuit being representative of a more relaxed standard on whether the trial court should be more rigorous in making decisions on whether someone was qualified as an expert. And the Eighth Circuit, as illustrated in the Finch case, that the trial court would make a very general, loose, relaxed threshold determination and then leave it to the jury to determine whether or not the expert was truly qualified or the opinions of the expert were generally accepted, to borrow from the Fry standard. The Seventh Circuit represented the circuits that said, no, a court really needs to serve as a gatekeeper. And if there are flaws and potential deficiencies in the underlying methodology and whether the expert is truly qualified, that is a decision of law to be made by the trial court. Juries are not better positioned than courts to determine whether someone is qualified as an expert witness. The new federal rule of evidence 702 became effective December 1, 2023. And what's important to note is, although there has been no conclusive Supreme Court case law on the subject, it's important to realize that the Supreme Court blessed the new rule. So I think it might be safe to assume, subject to future litigation, that the revisions to 702 have the support of the sitting U.S. Supreme Court. And the motivation of the committee was that the Eighth Circuit position, the courts that were not gatekeepers, had been a bit too lax in their approach, and that the gatekeeper approach should be followed. I'm putting on the screen now the new Rule 702. And it's important, I have showed in red line the changes to the new FRE 702. One important change is the standard for the court to determine. It's a more probably than not. Did the proponent demonstrate to the court that it's more likely than not that the expert's scientific, technical, or other specialized knowledge will help the trier of fact understand the evidence and determine a fact and issue. The testimony is based on sufficient facts or data. The testimony is the product of reliable principles and methods, and the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. Again, this is a decision to be made by the court, not reserved to the jury. Again, we have now, it's clear, a preponderance of evidence standard is the criteria for the court in making this decision, and district courts are charged with serving as the gatekeeper. And I'm relying heavily on the committee notes because I think it's influential, and courts often cite to the committee deliberations, certainly in the early stages of an amended rule, that the critical questions of the sufficiency of an expert basis and the application of the expert's methodology must be determined by the court before the expert is deemed admissible and presented to the fact finder. After the admissibility standard has been met to the court's satisfaction, attacks by the opposing party will only go to the weight of the evidence, not to the admissibility of the evidence or the ultimate qualification of whether someone is an expert. The committee said that the standard for admissibility, and now they're injecting some confusion into the equation, and we'll talk more about that later in the program, is merely whether an expert's knowledge will help the fact finder. And the committee specifically rejected the more onerous appreciably help standard that had been used by many courts. So on that point, maybe a bit of a win to the traditional personal injury plaintiffs, employee plaintiffs bar, who generally opposed further modifications to Rule 702. And it emphasized that courts, not jurors, are better situated to determine the reliability of the methods underlying an expert's opinions and whether the expert's opinions overreach what the expert's basis of methodology might reasonably support. And it also stated the court should not nitpick an expert's opinion to reach a perfect expression of supportable testimony. Clear as mud, right? And each of the four factors in 702 must be proved independently by a preponderance of the evidence. And kind of in summary, the court's gatekeeping role is really two-pronged. Is the opinion based on scientifically valid reasoning, and has the relevant methodology been properly applied to the facts? According to the committee, the expert's opinion must stay within the bounds of what can be concluded by a reliable application of the expert's basis and methodology.
My name is Donna Williams. I will be your host for what is always the most titillating part of one of these seminars, the case law discussion. I've tried to make it a little more interesting, as you'll see as we go through the slides. And I do appreciate Strafford granting me a little bit of leeway in use of external media in my slide presentation. For a bit of housekeeping, I am told that if you refresh your browser, you will find that there is a PDF file. I've prepared a really rough overview of the cases. I'm obviously not going to be able to go through every case, nor would you want me to go through every case. But I've tried to provide in the PDF that's available to you just a kind of a very brief overview and rundown of the decisions that have been handed down since December that discuss the amendments, and even some before December. My discussion will focus on a few points. We're going to start with cases I'm calling the overachievers. Then we'll move into some trends I've observed in the decisions that have been handed down, um, discuss those decisions, and then really brief appellate overview, because as you might imagine, there is not much in the way of appellate cases at this point. So our first topic is, the overachievers. And I see we have a blue box that didn't appear as a blue box on the slideshow I had. Well, I'll describe it to you. If anyone watches New Girl or has watched New Girl, Jake Johnson's character, Nick Miller, is sitting in a chair and in his own kind of snarky, snide way is clapping, saying, "You overachiever, you." That's what should be there on that slide. Now, I've called these cases the overachievers because these are decisions in which the courts discussed and decided the cases based on the amendments before the amendments even came into effect. And the winner of the Overachiever Award is the Fourth Circuit. Way back in 2021, the Fourth Circuit issued an opinion in Sardis versus Overhead Door Corporation. It was a products liability case. And the court relied on the proposed rules change before the rules officially were adopted in issuing what I took as kind of a clarion call to the component courts within the Fourth Circuit and to litigants, basically giving them the heads up that everyone should expect that expert evidence must be scrutinized and it has to pass muster. And in the Fourth Circuit, expert opinion, evidence, and testimony is not going to just be allowed to go to a jury because it has an outsized impact on the jury, and it's going to be vetted, and the courts need to exercise their gatekeeping function that James mentioned. And the court also discussed its deep concern over what it called the pervasive problem of some judges treating reliability and relevance as issues that go to the weight of the evidence and not the admissibility. And as Andy had mentioned, the advisory committee comments can be very persuasive and they can be relied upon by courts. And the Fourth Circuit quoted and cited to the advisory committee comments quite extensively in the opinion. The Sardis case is a very good decision, even though it's not employment, even though it's Fourth Circuit. Even if you're not in the Fourth Circuit, I think Sardis is a good case for you to keep, kind of in your legal research folder, just because it provides a thorough discussion of the rule, of the history, of the changes, of gatekeeping, of what needs to be done. It talks about the Daubert trilogy. And so I found it to just be a really good case to have on hand because, when you're filing your motions, you can go to Sardis. And even if you don't quote Sardis directly, you'll have the citations to other cases, to the Daubert trilogy, to the advisory committee comments, and you can just copy and plug them into your motions. And Sardis provides a very nice kind of toolkit for that. And not surprisingly, after Sardis was issued, there were a couple decisions rendered also in the overachiever category by Fourth Circuit district courts that were following Sardis and saying, yes, we understand that there's gatekeeping function and this amendment is coming up, and we're going to be following it, and it doesn't change things all that much, so we're just going to abide by the amendment before it's even in effect. And then the Eastern District of New York in an antitrust suit involving credit card fees also relied upon the rule before it went into effect. And that's a very thorough opinion. It may be a little too factually detailed for people to want to keep in their dossier, but it's a very thorough decision. And as James mentioned, there a lot of times in these decisions, it's not a full-on yes or no about an expert. There will be portions of an expert's opinion that will be allowed, and then there will be portions that are stricken. And that occurred in this credit card case, and we'll see that same occurrence in many of the cases going forward. Now, my next section I'm going to discuss are kind of trends that I observed in the cases that have been handed down since the amendment went into effect. I am going to issue a disclaimer first. I mean, no disrespect to any of the litigants, the courts, or the clerks. The cases are all well written, thorough. These are just my kind of off the cuff reactions. It seemed to me that the cases that have come down so far have fallen into kind of three categories. And my first reaction was there are the nope cases, the not me cases, and then the now we're talking cases. Here, my blue box actually is Paul Rudd's character in Anchorman. If you've seen that movie, it's kind of a memorable scene. And Paul Rudd says, nope. And I have a meme there of Paul Rudd saying nope in big letters. So that's what you can imagine. These cases are the nope cases, in my perspective, because there have been a number of cases handed down where the parties seem to try to use the amendment as grounds for a do-over. And in the do-over context, most of the courts, not surprisingly, have had the reaction of nope. They don't view these amendments as grounds to just completely throw open the doors to reconsideration of prior Daubert decisions or, prior 702 decisions. And there are quite a few cases that fall into that category. I have not included the nope cases in the PDF overview that I provided because they don't really address all that much of substance. They're just the courts, generally saying the rule hasn't changed things all that much. It's, the rule is saying what should have been done in the first place. And so, we, the courts, do not view the rule change as a grounds to reconsider decisions. So that leads into the next category of cases, which are the not me decisions. And the not me meme is David from Schitt's Creek with a typical David funny face saying, not me. And I've considered these cases the not me cases because there definitely seem to be a trend in some of the recent decisions of courts being a bit defensive, in my opinion, and kind of being like, oh, well, this is why the rule was changed because some courts were not fulfilling their gatekeeping function, but not me. I was doing it. That rule change wasn't directed at me. And there are a number of cases that kind of have that tone in my review of them. Um, and the decisions have come out just fine, and some of them were very thorough in their discussions, but I did note that there were quite a few cases where there seemed to be a little bit of defensiveness on the part of the judges about some of the advisory committee's comments. Now we get to now we're talking. So now we're talking. These are the cases that really dig into Rule 702 and really dig into the amendments, and that I have more of substance to talk about. And this meme is Stanley from The Office saying, "Now we're talking." If you've ever seen that. Now, the first case I'm going to discuss, it's not an employment case, but I find it quite interesting and potentially very significant. And interestingly enough, it's an exception to the nope cases. It's a yep case. In the Johnson and Johnson talcum powder lawsuits, just recently, I think it was just a couple of weeks ago, the judge entered an order in the MDL agreeing to reconsider prior Daubert motions and prior expert rulings. And as you know, that's a big deal. There were significant rulings issued. There was a lot of opinion in the legal opinion sphere about the prior expert rulings. Many people felt that there were opinions admitted that were not scrutinized properly under Daubert, and that there was some kind of uh, fake science being relied upon. And then there was a change in judge. And between the change of judge and the amendment to the rule, the defendants decided that they were going to, take their chances on asking for reconsideration of the expert rulings. And the judge who now has taken over the case said, yes, I think that's a good idea. I think there have been enough changes in law, fact, and Judge Wolfson relied on, or I'm sorry, Wolfson was the prior judge. The new judge said, and there's a rule change, so I think it's worth reconsideration. So there are going to be new Daubert motions filed in the J&J talcum powder case that are due by the end of July, and the oppositions are due at the end of August. And the judge was very clear, I'm not making any promises. I'm not saying that I am going to change Judge Wolfson's rulings. I'm simply saying that I think there are grounds that exist to make the filing of a new set of motions worthwhile. So that's a that's a big deal, I think. Not many judges are open to reconsidering rulings. So the J&J case is something that, you might want to keep in mind as well. If you're dissatisfied with a prior expert ruling, if you're lucky enough to have a change in judge, I think you'll have a better chance of persuading the judge to revisit the ruling than if it's the same judge. But there could be some pearls of wisdom and tactics to take in the J&J case. If you go into Pacer and pull up the briefs, that could be something good if you're dissatisfied and you would like to revisit a ruling. There have been a couple of other cases that I thought were quite interesting, and just that they suggested that the rule brought about a major change in 702 practice. And that seems inconsistent, I think, with with what just about everyone thinks about the rule. But there were a couple of cases, one out of Oklahoma, one out of the Eastern District of Missouri, where the courts suggested that there wasn't much of a gatekeeping function in the first place, and that there was a presumption in favor of acceptance of expert opinions, and that it was very liberal, very liberal standard applied in whether expert testimony would be accepted or not. And those couple of cases suggested that 702 changed the ball game in December. So I thought those were interesting cases. Um, and James had mentioned the gatekeeping function, and the burden on the proponent in propounding expert testimony. And he was spot on in his tea leaf reading, because many of the cases emphasize that. They emphasize that the rule is intended to make sure that courts fulfill their gatekeeping function, and that courts, have the burden in the right place, and that they don't just accept testimony or opinions or reports, just because it's offered. Um, and there have been the handout discusses some of those cases. Um, One thing that was interesting, there have been a few class certification cases that have been issued in recent months, and those have discussed the gatekeeping functions and the burdens, but there have been very different resolutions. A couple of the cases, the judges seem to be very lax in what they accepted, and the judge seemed to be, well, I think this will help me make my decision on class certification, and that was about the extent of the analysis, which then leads to the question of, I wondered if the judges would have had that same approach to the 702 motions if this was, talking about whether the evidence was going to go to a jury and not just evidence that a judge was considered. And then, but by contrast, in a customer data breach litigation on class certification, the court took a very detailed approach to considering motions to exclude expert testimony. And the court excluded the plaintiff's expert opinions because there was, in the court's view, an inadequate uh, indicia of reliability and methodology. And the court allowed a rebuttal expert's testimony, and that rebuttal expert seemed to guide the court quite a lot in deciding to exclude the plaintiff's testimony. So there are a number of cases out there discussing the gatekeeping function and the burden of proof. Overall, it seems like most of the cases issued since the amendment have indicated sort of judges leaning into the amendment to support them in excluding evidence, and in supporting the judges in really scrutinizing the testimony very seriously, which is great. That seems to be consistent with the intention of the rule changes. Um, and I've listed in the handout just, a lot of decisions that have come down personal injury cases, data cases, criminal cases. And that's been rather interesting to see. Some of the courts have rejected police evidence that in the past they indicated probably would not have been rejected, and it seemed like the amendment to the rule kind of bolstered the court's resolve in being willing to refuse admission of expert testimony that in the past had been admitted. Now there have been several, not as many, but several employment related cases that have come down since December, and these are all district court level. Several of them applied the amendment, and while rendering the 702 motion decisions, the courts made very clear that in light of the amended rule, parties cannot try to proffer expert evidence to simply state legal conclusions and to simply parrot the parties' theories and the parties' damage calculations. And that may seem self-evident, but when you go through Rule 702 cases, you see that a lot of parties try to do that. They try to use experts to basically just support their theory of the case, but the expert is not really providing any expert testimony. And as James talked about, the subjective opinions, the kind of changing opinions based on the case. And these courts have said no, that's not going to fly anymore. We're going to scrutinize this expert testimony very carefully, and you have to rely on the facts. You have to rely on a reliable methodology. You can't just come in and say what the party wants you to say. And then there was one employment case it was a trade secret case with some employment related claims that came out of the Northern District of Texas. The court there, the court was a bit testy. The party seemed to be using a Rule 702 motion instead of a motion to compel. And the court said, no, the amendment does not allow you to use Rule 702 to just try to get more information out of the other party. Rule 702 is about the admissibility of the experts' opinions and reports. It's not about you getting more information. And so if you're faced with a situation like that, it's a BHI Energy. It's in the handout. That's a case you could use to oppose someone who's trying to use Rule 702 to conduct a fishing expedition and not to address expert testimony. So the final point that I'm going to discuss right now, and I don't want to eat too much into the Q&A time, so I'll go quickly. It's the appellate overview. So as I alluded to earlier, not surprisingly, there's very little in the way of Circuit Court of Appeal decisions regarding the amendment, simply because, how long it takes for appeals to get briefed and argued and opinions handed down. I would say the Sardis case is an excellent case in terms of a Circuit Court of Appeal decision. Even though it was decided before amendment, it is based upon the amended rule. There was a Sixth Circuit case, Taylor versus Bristol Myers Squibb. It's a diabetes drug, MDL. The court mentioned the rule and briefly discussed the rule. That's a Sixth Circuit decision, the amended rule, but the actual decision was based on the pre-amendment version of Rule 702, just because the appeal was filed before the rule went into effect. Now, there is one case I want to mention. There's no decision, but it's a case to watch. It's pending in the Fourth Circuit. It's called Peninsula Pathology Associates versus American International Industries. It's technically not an appeal based on Rule 702. It's a case involving an order quashing a subpoena. However, the American Tort Reform Association has filed an amicus brief, and that amicus brief raises Daubert issues in Rule 702, and it is trying to develop this appeal into more of a 702 related case. So that might be another case in the Fourth Circuit to just keep an eye on. It might be the first post-amendment decision that actually discusses the amendment in some detail. So I just raised that as something to look out for. Again, it's Peninsula Pathology versus American International Industries.